es un programa que impulsa el análisis de los principales desafíos de nuestra región, vistos desde una perspectiva internacional. Queremos destacar la participación a lo largo de estos 26 años de más de 3.000 conferencistas y más de 120.000 asistentes. En el día de hoy tendremos la conferencia Debida, diligencia empresarial en derechos humanos, experiencia francesa de la ley del deber de vigilancia en la 26ª versión de nuestra cátedra. Los invitamos a utilizar la etiqueta numeral modo cátedra para hacer sus comentarios en redes sociales y a consultar la programación académica y cultural a través de la página web de la universidad. En el día de hoy tenemos de manera virtual a la doctora Nadia Bernaz, profesora asociada de la Wageningen University and Research, y en nuestro auditorio a Jeremy Perelman, profesor asociado de Sciences Po Law School, Sciences Po Paris, Nicolás Vanegas, director de Asuntos Corporativos y Engagement para Centroamérica y la región andina de L'Oréal, Miguel Barbosa, coordinador del proyecto Empresas, Derechos Humanos y Estado de Derecho de la Fundación Konrad Adenauer, y modera la profesora María Clemencia Serra, decana de la Escuela de Negocios de la Universidad del Norte. Bienvenidos. A continuación, presentará su ponencia el profesor Jeremy Perelman, profesor asociado de Sciences Po Law School, Sciences Po Paris. Bienvenido.
Hola. Bueno, empiezo. Estimada decana, estimadas y estimados colegas, chers collègues, primero me gustaría agradecer a la Universidad del Norte y en particular a María Clemencia Sierra y Javier Tus para invitarme y para toda la perfecta organización. Voy a seguir ahora en inglés, pero creo, bueno, ya veremos, que si tienen preguntas en español después, intentaré responderlas en español. Pero por ahora, muchísimas gracias al traductor o a la traductora. Y me dicen que ustedes entienden el inglés muy bien. Entonces, I'm going to switch to English, okay? If I speak too fast, just tell me, okay? Just do this. Okay, so I would like to begin by situating my intervention, which is both that of a professor and academic who has been looking at issues of human rights and sustainable development and the rising field of what's called business and human rights now for quite a while. And also the perspective of a relatively modest participant indirectly of the process which led France to be one of the first countries, if not the first country in the world, to do what's called piercing the corporate veil. Okay, that's an expression that some of you may know, that especially it classically denounces or used to denounce how corporations, and in particular parent transnational corporations, their shareholders and their executives, are or were protected by classic law principle, corporate law principles, from legal responsibilities for the human rights violations that may be caused by their subsidiaries or other partners along the value chain. Okay, and the idea was that France was one of the first country to pierce this protection, this corporate law veil, on the human rights duties and responsibility of parent companies by adopting what's called a binding, very large, it's not specific to one specific sector, as we'll see, law in 2017 called the French law on the devoir de vigilance, or the duty of vigilance. So the insider small part of it here is that I'm also, at my university, the director of what's called a clinical program in which students from law, international affairs, business, public policy, urban affairs work. They're supervised by academics and professionals, and they work with partners, and L'Oréal is one of the partners we've had for many years now, on specific projects during the year, and that goes into their curriculum, and they get credits for this. And many students have been involved in different stages of, the genesis, the origins of this law, and then in trying to implement it. And many of the people who either teach in these programs or were students in it have actually written extensively about this law. So what I'm going to do here is so that's the academic in me. I can't help it. But I'm going to try to give a very brief overview of this kind of the rise of business and human rights as a field. Give you a brief sense of what's called the UN Guiding Principles on Business and Human Rights, which might be helpful for the discussion later. Then something about the origin, the genesis, the creation, and the adoption of the French law. And then a couple of words on challenges, implementations, and maybe I will leave for the discussion later how I think it can be relevant for Latin America and the Caribbean context, but I know we have speakers who are better situated than this for this than me. So in terms of the general context, and Nadia, who I've met before and who's online, wrote actually a beautiful book about this and the history of business and human rights and more than the history. Okay, so human rights in 30 seconds. Many of you are familiar with human rights, but the way human rights became a system of international protection happened essentially after World War II. And the idea, very simply, is to avoid a repetition in which the iconic example is Germany. Germany, the Nazi government came to be democratically elected and then started to legally discriminate against some parts of the population and eventually eliminate parts of the population. And whenever there was a denouncement by other countries, Germany could say, well, I am a sovereign state in international law. No one can look into what I'm doing with my own citizens, okay? And after the horrors of World War II, there was a moment in which the United Nations, which was created partly under that idea, wanted to avoid a repeat of that. And it created a system in which a universally shared sets of values would kind of lie above state sovereignty, meaning that states accepted to have what they do with their own inhabitants be monitored, be examined by international treaties. So you have 10 international treaties of human rights or regional treaties. That means that what happens between a state and its inhabitants is now scrutinized by an international system of monitoring, of treating obligation, of legal obligations, okay? That was a revolution in itself, but the big loophole was that the only what's called a duty bearer of human rights, classically, is the state. So states themselves who sign on these treaties and accept to be monitored are the only bearers of obligation, and the idea is that they cannot violate human rights obligation, and they cannot especially discriminate depending on nationality, ethnicity, religion, thought, etc., or gender. So states, however, are not the only story. And many of you are familiar with the idea that starting in the 1980s and 90s and over the last 2 decades, there's been a rise of what's called economic globalization, right? Non-state actors, and in particular transnational corporations, have started to assume a large part of what states used to be doing, including the provisions of water, electricity, or services. So corporations, especially big transnational corporations, have started to play a really big role. So both corporations from what's called the global north, but also increasing on world market, all of that supported by opening your market to foreign direct investment. Okay, some people have also suggested that another model that happened, especially in the 1990s up to today, has been encouraging a lot of nations to engage into what some people have called a race to the bottom, right? A competitive race to the bottom in order to produce and trade cheaper manufactured goods and now also services. If you think about the call centers, for example, in some countries, by keeping, and this is where it's important, wages and labor and environmental standards relatively low so they can attract more investment, okay? As a result, almost mechanically, a lot of transnational corporations who were involved in that model have been involved directly or indirectly in a number of human rights violations, in particular with regards to the extraction of natural resources. So violations are not anymore only the result of state actions, but there's been, because of the role in transnational corporations in these new development models, export-led growth or race to the bottom, there's been a very well-documented number of increased violations of rights, which you can see here, okay? The problem, however, so violations of labor rights, forced displacements of populations, environmental degradation, complicity in crimes against humanity, that was something that was alleged here in Colombia, for example, in the famous case of Chiquita, the American company, which hired paramilitaries to protect their banana production in Colombia. But the problem is that there's a lack of legal framework, sometimes in countries which are receiving the investment. The idea is that these countries don't necessarily have the resources of a judicial system that can resolve or remedy some violations, or that countries want to remain competitive, so they won't do anything about it because they keep wanting to attract investment. And in the countries where big transnational corporations are established, there's this corporate veil, right? The idea that parent company were not meant to be liable. Okay, but there's been a big evolution. There's been a big reaction to some of the violations which are listed here, and there's been big moments in consciousness around the world. One of these was the Bhopal tragedy in India, 1984. In which 500,000 people were exposed to contaminating gas, and a lot of people died in a chemical plant owned by a US company, and the legal proceedings are never really went very far. Another more recent, which played an important role in France, is the Rana Plaza disaster. So Bangladesh in 2013, where more than 1,000 workers died in 5 garment factories that were all in a building that were supplying clothing brands, many of them European, because of a very, very, very low level of safety, work safety standards in these subsidiaries of companies. Okay, there's a couple of lawsuits which started to happen. I mentioned Chiquita in 2007. And as a result of this, and in parallel, to this heightened consciousness, at the global level, a number of initiatives started to happen. So you had initiatives such as the UN Global Compact in 2000, in which companies were sort of encouraged to report what they do with regards to human rights obligations and labor obligations. Some sectors like extractive industries or other sectors decided to do some voluntary initiatives to try to sort of avoid these kinds of disaster. But there was an effort at the beginning of 2000s to create actually a binding treaty that didn't work out. There was not enough support. So you had a guy called John Ruggie, who was a political scientist, who started in 2007 to consult. I happened to be in one of his consultations. This is a while ago now. And he tried to come up with a different kind of norm, not a binding treaty, but a kind of voluntary, what's called in law, soft law, principles for both countries and companies to know what they need to do in order to respect human rights obligations, okay? And the idea that John Ruggie had was that by doing something that is not legally binding, it would kind of stick with and attract both countries and companies to do more about it than if you were trying to impose them something legal. And to some extent, it happened, okay? So the guiding principle, so there was a first version that was adopted in 2008, but in 2011, the UN Human Rights Council adopted what's called the Guiding Principles on Business and Human Rights. And there are three pillars here. One is the idea that states have a duty to protect violations of human rights by corporations which are established in their country. So they essentially have to design regulation or laws that would make sure that companies in their countries do not violate human rights obligation. And we will see that France is an example of that. They also suggested that business companies themselves have human rights obligation, and that's the responsibility to respect human rights wherever you operate and whatever is the size of your industry. And in order to respect human rights, companies have to, first of all, know their actual impact. So they have to look at what they're doing and what kind of impact it may have. They have to prevent and to mitigate potential abuses, and they have to address impacts in which they have to be involved. Okay, and the third idea is that victims should have, if there are violations, a right to remedy, meaning they have a right to sort of demand some compensation. So either through court systems that states would imply, or so mostly court systems, or what's called grievance mechanisms. So companies themselves can create kind of a quasi, not a court, but a place where people can go and demand some reparation. Okay, so this has actually really generated a lot of positive impact. Companies have started to do things, states have started to do things, but one limitation is that it remains what's called soft law. It's not binding, really. These are UN guiding principles. It's not a treaty. And the idea is that maybe countries needed to do more. And even, as I said, there seemed to be an obligation for states to try to design laws and regulation to force companies to do more to prevent and, if necessary, remedy human rights violations. So one of the countries in which that happened is France. Okay, so now moving on to France, and France was arguably the first country to design a mechanism that is a binding domestic, so meaning French law, that imposes obligation on French. I'll show you the criteria on companies established in France for any kind of violations of human rights, health and security of people, and the environment. So very broad and a binding mechanism which allows people to eventually sue the company, go to court if the company has not done well. Okay, so politically, and what I'm saying here, I'm saying the story not so much because it's Catedra France, but also because maybe it might be resonant in Colombia or other Latin American countries. The political moment was key. It happened, so the Rana Plaza disaster happened in 2013. In 2013, the president in France was a center-left president, François Hollande, and there was a number of members of parliament who seemed to be really, affected by what happened. And there's a big coalition of civil society actors, Sherpa, Amnesty International France, CCFD, Terre Solidaires, those are the main players who sort of worked with members of parliaments, and this is where my half story comes in, universities, to try to push France to become the first country to actually act upon this and create a law. Okay, so I was approached along with a couple of my colleagues by Amnesty France in particular to try to come up with a report which we published with Amnesty in 2030 that basically suggested the different ways France could sort of apply these guiding principles. And the idea was that a civil society organization tried to leverage a university as a platform. That's interesting too, in order to sort of show that it was not just NGOs that were fighting, but there was actually some academic credential and research behind this. It's essentially a long story. There were many instances in which we collaborated, many roundtables until the law was finally adopted. Okay, but the one quick thing I want to say, because I think it's interesting for everyone here, and if we were in a class, I would ask you the question, but I don't have the time. Okay, because the question is, why would it be good for companies to adopt, to follow human rights standards, right? You could say it's not the bottom financial line. So the arguments that were made in that report and by a lot of people was that, first of all, corporations can be agents themselves of sustainable development. For example, if a corporation is providing water in a country, it's really important, and it has to do it in a certain way. The idea that companies are not about just shareholder but stakeholders, and it has a broader vision. But more specifically, there's what's called a business case for human rights. Okay, and this is where I usually ask my students, what's the business case for human rights? But I'm going to go fast and give you the main ideas. So one of the ideas is legal, right? You avoid legal risk, because if there's a law like this that says that you have to put into place monitoring mechanism to avoid and mitigate human rights violation, you can be sued. So you have to be careful, and there's more and more laws in countries that are trying to do this. The other one is operational. So the idea is that if you, as a company yourself, voluntarily try to come up with plans of action to respect human rights, you might have what's called a legal and social license to operate. There will be less fights, for example, in communities in which you're involved. Also, there'll be, your employees might like it. You might be able to recruit people like you because, you're, L'Oréal, for example, is, and I'm saying this here formally, is one of the good students in France of really doing that seriously. You might attract and retrain talented employees. Otherwise, we wouldn't work with them. We do work with them. So that's one thing. Financial, right? The idea is that it can have an impact on the company valuation, because some international organizations, the IFC, the International Financial Corporations, the lending arm of one of the lending arms of the World Bank for the private sector, or Export Credit Agency, banks, private equities, might not finance you if you're not doing this. And there's more and more standards like the Ecuador principles that are demanding that companies behave in a certain way. And reversely, they can be divestment campaigns if you don't do this. Okay. And finally, reputational, right? Your reputation today in social media, it's really important to have a good reputation. So the idea is that it could actually reinforce your reputation. So the three counter arguments that came up from businesses mostly, but not only. One, that, well, even if corporations are acting more and more in the sphere of the state, companies are not states, okay? And we cannot impose on them all the obligations of human rights. The other argument was that France was going to be the first one to do this. So all French businesses were saying what? They were saying, if we do this, we're going to lose our competitive edge. We're going to lose investment. We're going to be, more demanding to our companies than other countries in the world. So we're going to lose business, essentially. And there was a strong argument that rather than a binding law that offers a possibility for lawsuits, what you needed to do is follow a kind of more pragmatic Anglo-American approach, such as in 2015, the UK enacted a Modern Slavery Act, which included a clause in which companies every year have to report of what they're doing all along their supply chain in order to avoid what's called modern slavery. Okay, it's very limited in narrow, but it's kind of a voluntary reporting. And the idea is to say that, by doing this, it will sort of slowly but surely encourage companies to do it. And there was a strong argument by a lot of people, including people who are now working at L'Oréal in this sense. I'm not going to go through all the steps of the convoluted way from these ideas to become a law, but finally, after validation by the French Conseil Constitutionnel, so it's one of our three Supreme Courts, we have a lot of Supreme Courts in France, it came into force in March 2017, okay? See, I forgot my slides. So this is the slide. So I'm going to go relatively fast here because I know my time is soon up. But essentially, there's a specific kind of scope. So companies have to be established in France, and they either employ 5,000 employees, including subsidiaries which are controlled at more than 50%, or indirectly controlled because you own shares in companies that altogether represent more than 50%, or the same thing, but companies that are 10,000 plus employees, and you look at the subsidiaries globally too. So in practice, it means that a threshold in order to qualify to come under this law is big companies, right? About 150 companies. One of the problems with the law is that it's hard to know exactly all of these information, but it's a high threshold, but it's still there. The obligation is essentially to establish what's called a vigilance plan that establishes effective, we're not really sure what it means, measure to identify the risk and to prevent severe impacts. Again, that's not very sure what it means, on what I said earlier, human rights, health and security of persons and the environment, so very, very broad, that could result from a company's own activities, but also, that's really important, the activities of its subsidiaries and of the subcontractors and suppliers with whom the company has an established commercial relationship. So that's all legal language. But basically what it means, it's an obligation to establish a vigilant plans where you're going to say how you're going to do a certain number of things. And it has to look not just at the activities of your company, but at all your value chain, your supply chain and your value chain, your suppliers, your subcontractors, everyone involved. So it's really, really big. And it forces companies to really look closely at how the value of their products are constructed and who is involved, what actors, what subcontractors, etc. So what do you need to do in the vigilance plans? It has to do a number of things. You have to map out the various risks. You have to regularly assess the situation of companies. You have to take tailored actions to mitigate risk or prevent severe impacts. You have to have an alert mechanism established in consultation with the company's workers' unions. You need a system to monitor the effectiveness of measure implemented, and you need to publish what you're doing, which is really important, okay? If you don't do it, there are sanctions. They go in sort of different categories. One, if there's no direct damage to someone, anyone who has what's called an interest to act, meaning mostly NGOs and unions, because it's difficult for an individual to do it alone, can basically establish what's called a formal notice to a company to actually publish the vigilance plan, okay? And, it can go to a judge and ask that a vigilance plan be provided. There's another potential sanction. If there's actually real damage to a community or to individuals, there's actually the individuals or the communities can bring a civil lawsuit, so a proper lawsuit to seek damages resulting from a company's failure to comply if the compliance would have prevented the harm. For example, the idea is that, if the company had a monitoring system that would have made sure that workers were not exposed to, toxic material in where they work, by really looking into it, some people's health might have been, health problems might have been avoided. So the idea is, to look at if there had been, all of these things that were before, the damage would not happen. Okay. So the key principles really that really form the core of the law is that the idea of human rights due diligence, which was in the UN guiding principles, now becomes a requirement as a matter of compliance, right? Rather than other, obligation to report or to disclose obligation, there's something that now is a requirement. It establishes what in law is called a duty of care. So it means you have to have reasonable care. It's an obligation of what's called obligation of means rather than an obligation of ends. There are lawyers here who might know, but otherwise it's just the idea that you have to be reasonable in the kinds of mechanisms you put in place. You have to really be engaged to doing it seriously and reasonably. The important distinction here is that if there's a harm, if there's a damage, there is a possibility to bring legal action. It does not focus on a specific sector or issue like some legislation in the UK or the US do, for example, and it covers, as I say, the entire supply and value chain, and that's really kind of a bit of a revolution. So before I finish, a few things. There's been evolution in the law since 2017, including, for example, changes in what's called public procurement. Do you know what public procurement means? If you want to have a state contract with a state to be the contractor for water sanitation, for example, you have to compete. So since 2021, companies are not allowed to compete for public contracts if they haven't put together a plan de vigilance. There's also, starting in 2024, companies that are involved in agricultural and forest activities have to report a bit more with regards to the potential deforestation activities that they might be involved in. There was a 2020 report of the French National Assembly suggested that, so it's a positive outlook on what the law has done, says it hasn't affected French companies' competitive edge. It's actually protecting the reputation of French companies. It has helped attract people like you, recruitment. It has helped to secure financing, including public procurement. It enhances the control of the global value chain and the relationships with partners and subsidiaries. It responds to citizens' increased consciousness and demand as consumers and investors for an ethical globalization. And the idea that France, yes, France was first, but it's been followed. There's many laws, and we will hear shortly from Nadia about a European-wide initiative that follows likely very closely what the French have done. Okay, there are, however, just to finish, some challenges. I won't bore you with the legal detail, but there's some challenges. So the law in France is usually followed what's called regulation that really is supposed to detail what the law means, and it still hasn't happened. So the scope exactly and the reason we know that is that sort of our program has been involved in different ways to try to implement the law. So we work with companies to try to have them draft the plan de vigilance, the duty of vigilance. We did this a little bit at the beginning with L'Oréal, but also with Alstom and other French companies. We train judges so that when lawsuits would come, they would interpret it in a progressive way. And we've actually helped some NGOs to prepare what's called strategic litigation. The litigation is a litigation you choose to try to, show what the law has, inside it by having a judge pronounce it. Okay, and these litigations are happening now, and we're involved indirectly in some of them. So there's issues with regards to, knowing the scope of which companies are actually come under the law, what kinds of exact obligation, what does effective or severe impact mean, how to get the exact list of subsidiaries that are involved. NGOs have a very hard time to know this, and companies themselves sometimes don't want to publish or have a hard time because it takes a lot of work to actually figure that out. There's an idea that L'Oréal is not one of these, but many companies have not consulted NGOs or unions or what's called stakeholders to co-construct their mechanism. Total is one of them, the petroleum company, for example, and that's maybe one of the reasons it was sued. Okay, I won't go more into this. There's been a couple of lawsuits. There are lawsuits now which are trying out what a judge will say with regards to this. One, two important against Total, the petroleum company, which have been rejected actually recently by the court for reasons of procedures. One against BNP Paribas, which is a big French bank for lending to fossil fuel companies. And there's another one also at the time. So potential relevance for Latin America, maybe I'm not well placed to do that, but I would say, of course, French companies have to be aware of their own obligations, and maybe they could present themselves having a reverse competitive edge because they have, if they follow these vigilance plans, they're really at the cutting edge of what's done today in terms of compliance. For local companies, I would say, the political moment in France was important, and the political moment here today maybe is one in which there's uncertainty about investment, but maybe it could be an opportunity to do things in a way that will, benefit local companies, both in Colombia, but also, more broadly as they themselves invest in other countries in the region. And there's also a notion of regional dynamics. So in Europe, France and then the Netherlands and Germany have all enacted domestic initiatives, and now there's a European-wide, effort. And I read that there was recently a Latin American Caribbean tax summit in Cartagena. So there seem to be, regional initiatives. So maybe this is also a way to sort of, get out of a race to the bottom and try to enhance, regulatory, labor, human rights, and environmental standards. Okay, thank you.
Muchísimas gracias al doctor Perelman por su ilustración y ahora damos paso a la doctora Nadia Bernás, profesora asociada de la Wageningen University in Research, que nos estará acompañando vía Zoom.
Hello, everyone. Can you hear me?
Yes.
Okay. I had no sound for a second. Can you hear me now?
Yes.
Okay, great. Let me share my screen. Is it okay now? See my slides?
Yes, Nadia. You can go ahead.
I cannot hear you. Is it working?
It is working. You can go ahead.
Okay, great. Thank you very much. Thank you for having me and for the invitation to speak about the Diligence Directive. I'm really sad not to be in Colombia to speak to you in person about this important topic. So thank you for this invitation. Nonetheless, though I am speaking online, of course there is a strong connection between your university, and Matthew University. Professor Tools spent 9 months in my group last year to work with us, and it was wonderful to have him. It was wonderful to have you, Javier. You are missed every day. Conveying what everybody has told me when I told them you, when I told them speaking at your conference. And so I really hope that next time I will be able to make it in person. I'm sorry I'm not there. So today I was asked to talk to you about the proposed European Corporate Sustainability Due Diligence Directive. So I will take a bit of time to walk you through the key features of the directive, also in light of the presentation that was just given, introducing you to the French group, which is very similar, as you